Muslim or Christian, no minority is safe in India. Hindu extremists are killing at will without any consequences. India's future as a plural society is in danger. India's constitution is being eroded.
This is the cost of speaking truth to Modi, Amit Shah.
The world needs to wake up. The world needs to stop India from killing its minorities. Join us to hear experts speak on India's descent into Hindu extremist anarchy.
All right, thank you. We will wait another minute or so. Let's have more people join. Thank you, Avani, for joining us. It must be what, 10 o'clock, past 10 o'clock in India?
Thank you, Ajit. Thanks very much for the kind invite. Yeah, it is 10 p.m. in India.
Yes. Sukhman, you're in New Jersey, right?
I'm in Manhattan, actually, in New York.
We're in Manhattan. All right. Okay. So let's just start, and we'll have more people keep joining. Hello and welcome to today's webinar. Today's topic is Indian Judiciary Complicit in Religious Freedom. Can you hear me? Can everybody hear me?
Yes, Ajay, we can hear you.
All right, great. So this webinar, as you know, is being organized on the sidelines of the International Ministerial to Advance Religious Freedom, which is currently being held virtually with participation from around the globe. This year's ministerial is being organized by the government of Poland. The last 2 years, it was organized by the United States government. And this webinar is brought to you by Indian American Muslim Council, which is a nonprofit registered in Washington, D.C. It has this organization was set up in 2002 following the violence against Muslims in the state of Gujarat when Mr. Narendra Modi was its chief minister. And as you will recall, more than 2,000 people had died in that violence. Many of the top people who were complicit in that violence have not been convicted. They have not even been tried, including Mr. Modi. And the Indian judiciary's record in the cases of the Gujarat violence is patchy at best. And in fact, it is slightly better than in most other cases of religious persecution in India because of the efforts of the civil society. We have, for the last several years, we have seen that the Indian judiciary has failed to respond adequately to the demands of justice by India's religious minorities who have faced increasing persecution at the hands of Hindu nationalist extremists who are connected with the Rashtriya Swayamsevak Sangh, the RSS. As we know, the RSS is an organization that was founded in 1925 on the explicit goal, with the explicit objective of converting India into a Hindu nation with the second-class status for its non-Hindu citizens, minorities, especially Christians and Muslims. Thousands of Muslims in the last 20 years have been jailed across India on baseless and fabricated charges of terrorism and sedition, but also for merely expressing their right to political dissent and peaceful protest. Many Muslims are accused of non-existent crimes of love jihad. It's just crazy for Westerners to even understand the concept of love jihad. You would never even get by with using this kind of phraseology in the United States, love jihad. But we have, just yesterday, we heard from Madhya Pradesh, the central Indian province, that the government there, which is of course the government of the BJP, which is Mr. Modi's political party, is actually going to legislate a law criminalizing the act of love jihad, which is nothing but interreligious marriage by Muslim men and Hindu women. In tens of thousands of cases, with rare exception, India's judges have sadly reflected an increasing acceptance of the anti-democratic and bigoted assertions of the Indian police and prosecution. Whereas Muslims are overwhelmingly denied bail, non-Muslims are almost always set free. Hardly ever do Indian judges question the nonsense theories of Indian prosecution. I have myself, as a reporter in India, as a journalist in India, I have reported in cases where the judges have merely looked at the prosecution's collection of so-called evidence and said, okay, it is accepted and we will go to trial. They have not even questioned through the trial. There have been so many trials where the judges have not even allowed the defense to speak, the defense lawyer to speak. And trial courts overwhelmingly convict Muslims on zero or flimsy evidences. Oftentimes, we have seen that higher courts have had to overturn the rulings of the trial courts, but not before the Muslims have spent years behind bars. Similarly, Indian Christians are routinely victimized by Indian judiciary, which buys into the unfounded, fanciful stories of the Indian prosecution about Christians forcibly converting Hindus to Christianity. At the same time, Hindu mobs that vandalize churches and Bibles and carry out violence against Christians go scot-free from the courts. To discuss the behavior of the Indian judiciary towards India's religious minorities, I'm joined today with Avani Bansal, an attorney with the Supreme Court of India. Avani she is the founding partner of Avani Bansal Chambers. She runs Hamara Kanun, which basically in English translates as Our Law. And it's a legal awareness project which explains important laws in simple Hindi, which is one of the national languages of India, in a video format on YouTube. Avani has stellar academic record, winning 8 gold medals at the Hidayatullah National Law University in Raipur district in India, where she pursued her BA and LLB, which is the law degree. Thereafter, she pursued BCL and MPhil in law from University of Oxford in the United Kingdom, and she holds an LLM from the Harvard Law School. While at Oxford, she was the president of the Oxford Lawyers Without Borders. She was the associate editor of the Oxford University Commonwealth Law Journal and was the first law student to be highly commended as part of the Vice Chancellor's Civic Award scheme for her pro bono work in community caring. She was a recipient of scholarship for an academic exchange program to Max Planck Institute for Comparative and International Private Law, Hamburg, Germany, and has interned with the UN High Commissioner for Human Rights, Geneva, amongst others. At Harvard, Avani was the co-president of her LLM class, vice president of Harvard India Student Group, and LLM representative with South Asian Law Student Associations. She receives the Dean's Award for Community Leadership at Harvard Law School. No wonder she's so outspoken in India. She's also passionate about access to justice, gender rights, pro bono policy in India, constitutional law, environmental law, and social change. She has delivered lectures around law schools in India and has been featured in The Week, The Times of India, etc. We also have with us Sukhman Dhami. Sukhman is we have partnered quite often with Sukhman. He's based out of Manhattan, New York. He's the co-founder and co-director of INSAF, which is a human rights organization that was set up in 2004, 16 years ago, to work towards ending impunity and achieving justice for crimes against humanity in India, with a special focus on the Indian province of Punjab. Successive Indian governments have actually actively colluded with guilty law enforcement agencies and their officials that were involved in more than a decade-long persecution of Indian Sikhs in the 1980s and in the 1980s. And that persecution still continues because most of the people who were victims of that persecution, the families of survivors, have not been given justice. You will be surprised to know and shocked to know, public memory is short, people have forgotten, but tens of thousands of Indian Sikhs were extrajudicially killed by Indian law enforcement agencies, and not a question was asked. This was back in the 1980s and the 1990s. Sukhman was the recipient of the 2004 Unity Award from the San Francisco Coalition of Minority Bars and South Asian Bar Association for his outstanding service to the legal community. He is a 2006 Echoing Green Fellow and also received a 2-year fellowship through the Ford Foundation to work with the Center for Justice and Accountability. Sukhman has published several articles and reports on human rights in India with The Hill, Christian Science Monitor, Human Rights Watch, and the Public International Law and Policy Group, where he also serves on the advisory board. He earned his JD and MA from the American University. I'm also joined, he is one of the attendees, not scheduled to speak, with my very dear friend, my brother and my colleague, Matthias Patula of International Christian Concern. He works as Director of Advocacy with International Christian Concern. He's based in Washington, D.C. We are fellow travelers. We are partners in advocacy and justice. And he keeps a very sharp eye on the goings-on in India with regard especially to the persecution of Christians in India, And I hope that at some point in time, he will be able to speak on how Christians are targeted by the Indian law enforcement agencies today and in India, and how the Indian judiciary responds to it. I'm sure he will give us an overview. But first, before we speak to our esteemed panelists today, we would like all of you to hear the personal story of Wahid Sheikh. Wahid Sheikh is a teacher from Mumbai. He spent 9 years in prison in India, in Mumbai, falsely accused of carrying out a terrorist attack that killed more than 180 people in 2006. So I'm requesting my colleague, Mr. Muhammad Jawad, who is the National General Secretary of Indian American Muslim Council, if he could please play the recorded interview of Wahid Sheikh. Thank you.
This is Wahid Sheikh. Today, I speak here of what I believe is one of the most troubling developments of our time, the deterioration of the Indian judiciary. Some of the recent judgments like Babri Masjid demolition case and Ram Mandir construction case are glaring example of how the judicial system is under total control of the government in power, and how the government is using the judiciary to persecute religious minorities. The starkest representation of the court's decline can be seen in its failure to perform as a counter-majoritarian court. I emphasize counter-majoritarianism because it is important to recognize the role of the court in protecting the interest of minorities. The current government of Bharatiya Janata Party, which is in power, has openly espoused Hindutva, an ultra-nationalist ideology marked by extreme animus towards Muslims, Christians, and other religious minorities. The result over the last few years can only be termed as an assault on human rights and religious freedom of minorities that is shocking both in its intensity and its brazenness. The human rights violation of religious minorities cover a broad spectrum, from illegal detention, torture, and fake encounter killings of detainees to open assault against individuals like lynching, their sources of livelihood, and in many cases, their places of worship. Hundreds of Muslims have been arrested on trumped-up charges of terrorism and have spent several years in prison before being finally acquitted. For example, Mirza Nisar of Kashmir and Muhammad Nisaruddin of Karnataka spent 23 years in prison. The role of judiciary, which should have been that of a watchdog, are unfortunately in hand in glove with the administration and is equally responsible for the injustice being meted out against the religious minorities. Unfortunately, I was also a victim of this anti-minority state machinery. I was targeted purely on the basis of my religious identity. I was falsely implicated and arrested in the 7/11 bomb blast train blast case. At the time of our arrest, we were very confident about the independence and honesty of the judiciary and had high hopes of getting justice. We were assured that we would be able to prove our innocence in the courts of law. But the judiciary acted like a stooge of the administration with no concern for truth and justice. In 2006, I was arrested in the Mumbai train blast case and produced in court of law. From the first day itself, the behavior of the court clearly indicated their pro-government leaning, as is evident from their biased attitude towards the accused. Few glaring examples of omissions and commissions of the courts are as follows. Number 1. The charges put against us by the police were accepted prima facie and all our complaints were considered false and mere allegations with malified intentions, hence summarily rejected. Number 2, 7 cases were registered for 7 different blasts that occurred and the police demanded police custody in each of these cases, and the court accepted the plea of the prosecutors. We were sent to the police custody for each of these cases. As a result, we were in police custody for about 17 to 18 days, 7080. The police used this time to frame us in conspiracy and extract false confessions under duress. Later, when the police came up with the theory that all the blasts were linked and under single conspiracy, the court again accepted their plea and all the cases were clubbed under a single case without questioning the earlier stand of the prosecution. On the contrary, in the recent case of Mr. Arnab Goswami, the court did not grant even a single day custody to the police in the abatement to suicide case. Why? Just because he is a Hindu and is well connected with the intelligence department? On the contrary, we had to suffer the torture of 17-18 days police custody simply because we are from minority community. During police custody, whenever we were produced before the courts, we complained about the police torture, but all this fell on deaf ears. Even when hospital reports and signs of torture were produced before the courts failed to take any action against the police. The court were of the belief that Muslims are the real terrorists and perpetrators of the crime, and they are the ones who are making false allegations against the police. The public prosecutor too took a stand that the Muslim accused are following the Al-Qaeda manual and making allegation of police torture to derail the investigations. Number 4, all the special laws which have been enacted over the year have become instruments in the hands of police to falsely implicate Muslim youth and keep them behind bars for years without hearing. When such laws are challenged, even the Supreme Court has failed miserably to give justice and has always supported the prosecution without an iota of concern for human rights, truth and justice. Number 5, the Muslim implicated in terror cases are tried under two separate laws of the state, MCOC A, and one central law, UAPA. It is pertinent to note that the MCOC A confessions recorded before the police is admissible evidence against the accused. The police are thus able to keep the accused behind bar for a long period by extracting confessions under duress. On the other hand, Hindu accused of terror activities are not charged under MCOCA, or the charges are dropped later to give them relief. The Malegaon blast case of Pragya Thakur and other is a glaring example where the charges under MCOCA were dropped by the courts, whereas in our case, even the Supreme Court found it fit to apply MCOC against us just because we are from the minority community. Bail is the right of every accused. However, it is very difficult for a Muslim to get bail even in minor cases, whereas people like Pragya Thakur are granted bail for flimsy reasons. Here again, the bias of the judicial system against the Muslim is quite evident. Number 7, we had requested for medical treatment with doctor for our choice, which was rejected by courts. However, Pragya Thakur was granted hospitalization during custody and was even granted to get treatment from doctors of their own choice. Number 8, we had requested for use of laptop for legal documentation work, which was summarily rejected, whereas the Hindu accused were easily granted this facility. Number 9, parole, death parole and furlough are basic human rights of the all convicts accused, which are always rejected by the prison authorities in our case, and whenever we approach the courts, it has failed to give us these rights. Number 10, the court have continuously given time and patient hearing to all the prosecution witnesses, where the witnesses which we wanted to bring for our defense are either rejected or were not given a patient hearing. Number 11, fair trial is the right of every citizen under the Constitution, but Muslims never get it. False witnesses tutored are produced before the courts. The police even help the witnesses in identifying the accused in the courts during the identification process. Number 12, Speedy trial is the basic requirement of swift and fair trial. Fair justice system. However, cases involving Muslim accused drag on for years. For example, trial of Indian Mujahideen case in Mumbai court not started since last 13 years. In our case too, Sessions Court delivered the judgment after long 10 years without bail, and now the case is pending without any movement for the last 5 years in Mumbai High Court. In Mumbai High Court, around 4.5 lakh cases are pending for hearing, but irony of fact that Mr. Arnab Goswami case is being heard on priority in a day. Seeing this double standard nature of the court, we had raised a banner of no faith against the judiciary in the year 2007 and had submitted an application regarding the same. I feel that the court have been totally sold off. It has become a stooge of the government with no concern for truth and justice. Courts are just following the dictates of those in power and in fact only dictating judgments in the way the government asking them to do. Whatever defense witnesses were produced, the courts took selective inputs from their deposition and used them against us to sentence us to death and life imprisonment. The ATS wing of the police arrested in terror case falsely implicated us, tortured us both physically and mentally, produced false witnesses against us, and the court, instead of minutely scrutinizing, became hand in glove with the investigation agency and supported all the falseness and lies. The court of law are totally implicit in the arrest and torture of Muslims and sentencing them to life imprisonment and death in many cases. Muslims in India are facing harsh brutality of the police administration in one hand and biased approach of the courts on the other. It seems that being a Muslim in India in itself has become a crime.
Thank you so much. We just heard Brother Wahid Sheikh. It's a heartbreaking story. It's truly a heartbreaking story. What makes it even worse is that, in India, Wahid Sheikh is not a rarity. He is not an exception. That is the story of, and I'm not exaggerating, of tens of thousands of people across India. This is the story. I was a reporter, a journalist in India. This is the story I have investigated from across India, from India's more than 28 provinces. Everywhere the police have behaved in a similar way. Later in this webinar, we will hear our brother Sukhman Dhami talk about how the same story has been done with, it's a repeat of the story that's happened with Indian Sikhs in the state of Punjab. Let me come to Avni Bansal. Avni, would you like to go and talk to us, take your time and talk to us about what you think ails the Indian judiciary? Why does the Indian judiciary appear so biased or one-sided, or why does it have a problem? Why is it its behavior different with India's minorities? So Avni Bansal, take it away.
Thanks very much, Ajit, and thank you so much, Indian American Muslims Council, for inviting me for this talk. I must say that just the very title of this talk and the fact of attending it made me a recipient of hate messages from right-wingers who took a liberty of, filling my WhatsApp messages with, some very hateful messages. So one can imagine that this very title is very, very provocative. Now, Ajit, allow me about 10 to 11 minutes time to, give a little bit of context for those who may not be in a know-how of, how things are moving in India, and things are moving pretty fast in very many ways. That fast is not necessarily good, but allow me to, build a little bit of context and then answer your specific question, albeit, of course, from my subjective lens. So let me begin by saying that, the test of a person, Ajit, I very strongly believe, and of a nation, is how it fares during tough times. That's a test of a character. And India, not as a nation, but India as an idea, has a very rich and unique history, which has withstood many, many, many difficult times, and has always responded not as some sort of a straight, jacket formula, but in a very unique way, crafting a very unique evolution story as a nation and as a democracy, which is, in my opinion, unparalleled to what we have seen in any other country in the world. Having said that, of course, India as a democracy has had some very similar patterns to similar parallels from what's going on around the world. For example, on the specific topic, when we are trying to critically analyze the role of judiciary in India, albeit in terms of religious persecution, it's not far-fetched to kind of look at what's happening in Turkey or Hungary or Poland. So of course, there are parallels to be drawn. But the point I'm making is essentially this, that India's history is unique in many aspects, and so is its present. Now, what we are witnessing in India, broadly speaking, in my opinion, is a deep churn. And this churn has to be understood. Now, we had one single political party, the Indian National Congress, that has been in power in India for the majority of the 7 decades after India's independence. And every party in the world, which is in power for that long a time, is bound to see a downfall, because the wisest do catch up, and every party needs to keep up with the changing times. Now, what has made Indian National Congress as a political party be in power for so long is its underpinning ideology that seems to be really, the heart and soul of the idea of India. And I suggest and I propose that can be captured, in my understanding, in broadly 2 words. One of them is secularism, secularism very unique to India, and the other is liberalism. But when we see at the BJP, the party in power today, and we see its influence and we hear these stories, it's a kind of perplexing at the start to understand how this change came about. It's also easy to take a skeptic view and go to the other extreme and say that Indians are no longer secular. Indians, majority of them, no longer believe in the idea of a liberal state or a state where unity in diversity truly flourishes. And I would suggest caution there, because I think that the way BJP has come into power, while today they may seem at the height of their power, that really has been, intensive doing on their part for at least last 50 years or so. So last 50 years, BJP, fueled by, the RSS, has very craftily cultivated an alternative narrative to India, where surprisingly to us today, who may look at this without the contextual history, the large majority of Hindus are, being fed a narrative that they are in danger. But I would say that, that's not the full story. That's part of the story, right? The appeasement politics played by political parties across the spectrum has definitely had a role to play. The systematic capturing of institutions, judiciary being, of course, one of them, but there being other institutions, for example, the Election Commission of India, for example, the police, for example, the civil society, and a systematic decimation of the civil society in India. Now, all of this are different parts of the puzzle. When you put them together, only then can we try and see, what's really happening, and then kind of from that lens try and understand what's happening in the judiciary in particular. Now, it is, let me say, coming to the Indian judiciary and having a look at it, narrowing down our lens on the Indian judiciary. Let me first say that it would be unfair to paint the entire Indian judiciary with one brush. I feel, and I've seen in my experience of about a decade of litigation practice, that right from the judicial magistrates to the Supreme Court judges, there are some very, very honest, judges whose integrity, I may say, has what, is what has led to the holding of the fort, so to say, in the current time. So there are some very, very honest, dedicated, forthright judges. But what we are seeing is this overall growing perception of the Indian judiciary, where unfortunately Indian judiciary seems to be drawing flake not from one quarter and not on one issue, but on very many systemic grounds. For our audience, and in the interest of time, I want to make two specific proposals. The first of these being that the major problem as I see with, or the challenge as I see with the Indian judiciary, the first one is that there seems to be a lack of predictability, uniformity, and procedure being followed in the way that it is supposed to be followed. So this is my first, I wouldn't say charge is too strong a word, but I think this is a major challenge that at least in terms of perception, it's being seen that the same judges are applying the rules not uniformly, right? And that means that this old adage on which any justice system is based, that justice should not only be done, it should also seem to be done, seems to be terribly shaken. And that is bad news. And I'm going to very quickly give one example, each of the three words I've used very, very carefully in responsibility. That is lack of predictability, uniformity, and procedure. But before doing that, let me come very quickly to my second challenge as I see with the Indian judiciary today. And that is that a lot of times you don't have to take an action to be criticized. In fact, a lot of flake that the Indian Supreme Court in particular is drawing today is because of a lack of action, because of very slow action, which almost practically amounts to no action. And I'm going to give you an example of that. And then I'm going to give you one personal narrative and then, finish my initial comments for the day. So let me begin with the first word, right? That is lack of predictability. Now, any legal system is based on the idea that legal principles will be applied similarly to similar situations. Now, of course, as lawyers, we know very well, in fact, how to distinguish two cases on the facts of it, right? But when people see that in India, as all of you may be aware, there was this huge furor against the whole Tablighi Jamaat issue when the COVID-19, was at its peak. I mean, in India, we're still awaiting the third wave, so it's still not kind of subsided. But you all must have read some things and must have had some views on Tablighi Jamaat furor, right? And then we had the Jagannath Yatra case, and some of you may know that Jagannath Yatra is basically, a procession taken off Lord Jagannath, who is very, very popular in Orissa, the state of Orissa. And it is usually visited by thousands and thousands of people, if not lakhs of people every year. The court said that it's going to allow the procession, of course, with limits. But I mean, nothing prevented the Supreme Court from a common person's perspective to invoke the ground of health. Health being a concern, we didn't necessarily need this procession, right? But the Supreme Court gave it a green signal and it went ahead anyways. So where is the same treatment, one may argue, without going into the intricacies of the various legal arguments that the lawyers, of course, put forth in the courtroom. Let me give you another quick example. Now, Sabrimala, as some of you may have heard, is this famous, infamous judgment which was hailed by the feminists when the judgment first came. Sabrimala Judgment is basically, it was challenging a practice in a very popular court in the state, it was challenging a practice in a very popular temple in the state of Kerala, where women of a certain age, basically menstruating age, were not allowed entry into the temple at all. And the Supreme Court in its judgment said that, this practice is discriminatory against women, and that was hailed by everybody, only for the judgment later to be subjected to a review petition. Now, for those of you who don't come from a legal background, may not see the irony, but those of us who are practicing in India will know that review petition, simply meaning the Supreme Court reviewing its own judgment once it has been given, does it very, very rarely, and usually when there is a prima facie mistake or when something important did not come to the court's attention. Now, this very, elaborate judgment being subjected to review and the court issuing notices that other cultural religious practices, which are also derogatory of the women's right, the court is also going to hear all of those along with the Sabrimala petition, was seen by many as an attempt to dilute the otherwise wonderful judgment that came up in Sabrimala. So why this kind of, exceptional use of review powers when for 7 decades of the Supreme Court's jurisprudence, review power has never really been used like that, is a question that remains on the minds of many. Let me very quickly then move to procedure. So predictability, Sabrimala, right? Review jurisprudence is being used in a particular way. Why craft out an exception and uniformity, when there's so much furor around Tablighi Jamaat, right? Why not invoke the exception of health in allowing the Jagannath procession? And then let's talk about procedure. Now, all of you may have heard that, the anti-CAA protest in India, specifically in Delhi, was widely covered by the media. The Shaheen Bagh was obviously a prime example, but there were at least 13 other protest sites that had sprung up in Delhi in different parts. Now, what starting, February onwards, what the Delhi police and along with different police personnel started doing was trying to arrest a lot of young people, including journalists, a majority unfortunately Muslims, and started registering FIRs against them for their alleged involvement in the riots case. Now, so basically, just to kind of cut a very long story short, there were several people who were protesting against the Citizenship Amendment Act, and there were, of course, a group of people, primarily from the BJP, who were supporting it. There were some very inflammatory speeches given by the BJP leaders like Kapil Mishra, Anurag Thakur, and others. There was no FIR against them. There have still to be, legal proceedings taken against them. And on the other hand, even in March, we saw about 3,500 people, mostly young people, anybody who was basically dissenting, on CAA was in a way, arrested and FIRs were launched and false cases were fabricated. Just to give you one example, it became hugely popular. You can all read it on media, is a case of Safura Zargar. Now, Safura Zargar is this young woman who was basically, dissenting against the Citizenship Amendment Act. And the FIR said that she was trying to block a road and therefore apparently allegedly had a role in the communal riots that broke out, in the aftermath of these anti-CAA protests. And she was in jail for a very long time before being finally released on bail. And the question one has is that if you talk in terms of procedure, there has to be, bail is everybody's right? Like the first speaker said, it is a very clear jurisprudence in India. But when there is such flimsy evidence, right, how do you hold these young people in jail, for such a long time? Now, I know the first speaker said, 60 or 70 days in jail, he said seems like a long time, and absolutely. But what would you make of the fact that there are so many people in India, some of them I know personally, who have been arrested in February 2020, right before the COVID scene became like a major scene in India, and they're yet to be released on bail. Forget about bail, right? There were several reports that came out that some of the basic procedures in criminal procedure court, which is basically the procedural law that applies in India, some of the basic provisions of it were not followed. For example, the moment police picks up a person, arrest a person, the police is required to release their information at the local police station. Basically, there should be some information of who's been arrested. And there are thousands of people who have been arrested. And even when 150 days had passed, none of this information was in the public domain, right? And I promised you a personal story, and let me tell you this very quickly. So one of the activists who was kind of leading the protest, one may say, at Khureji Khas, which was the other big protest site after Shaheen Bagh. Her name is Ishwar Jahan. She is a lawyer, surprisingly. She was a municipal councillor. So Ishwar Jahan was arrested along with Khalid Saifi on 26th of February. A few of us got a frantic call that the police has picked them up. With 10, 15 of us human rights lawyers who went to the police station. She had informed us the police is taking me to a particular station. And just before her phone was taken away, she kind of, left these frantic messages. We go to the police station. And as a lawyer, we know that every person who has been arrested has a right to legal counsel, to legal representation. We as lawyers representing her should have a right to meet her. not only did the police deny us any meeting with her, they absolutely denied that these people were being held at that particular police station. What's more, when we insisted that we meet the police officer in charge, there was a lathi charge, meaning we were beaten by the police sticks, us lawyers, right, with several of my male colleagues having marks that lasted for days. And if you're thinking, well, what did we do about it? Did we just sit silently and take it? No, we went to the Supreme Court. In fact, we filed a matter. It was called Apni Bansal versus Union of India, and we made the relevant police station and the police officers a part of it. We were represented by a senior advocate, but the Supreme Court just said we're not going to entertain this, because the police is involved. It's the Delhi police. Why don't you go to the Delhi High Court instead, right? Basically playing on jurisdiction. And our claim was that the police's behavior is not just limited to this particular case, but we were hearing reports where police personnel across Delhi were in one way or the other not allowing the lawyers to meet the people who had been detained and arrested, thereby ensuring that the fundamental rights, to every arrested person is being denied. But the Supreme Court did not see that larger issue, right? And at later point, we realized that basically it's not going anywhere, and we had to kind of take a back step. But that is that. This is to give you an idea that sometimes, the Supreme Court, it's not just directly in terms of religious prosecution, but it's also in terms of, how the judiciary sees the role of the police. And thereby there are two institutions, police separately and judiciary separately. But there is, some sort of a dynamic that you see that you obviously cannot appreciate in the legal light. And so this is my first charge, right? There's lack of predictability, uniformity, and basic procedure in very many cases, if not all, of course. And then the second challenge that the Indian judiciary, I think, is facing is this slow action on some matters and inexplicable speedy action on others. So the first speaker, for example, obviously pointed out about the Arnab Goswami case, and everybody in India is asking, how does a journalist, Mr. Arnab Goswami, gets such an expedited hearing at the Supreme Court, where several other national importance matters, talking about Article 370, abrogation of Article 370, right? It's been more than a year now. There has been a plea filed in the Supreme Court for initiating the hearings, more than a year, and the hearings in the Supreme Court on Article 370 has not begun, right? During this entire time, right after the abrogation of Article 370 that took away the special status of Jammu and Kashmir, the internet services in the state of Jammu and Kashmir were suspended. And one could imagine the difficulties that the people across Jammu and Kashmir had to face, especially during the COVID times, where they don't even have access to 4G internet. Now, why has the Supreme Court taken such a long time in hearing the batch of petitions related to Article 370 is a question that needs to be answered. So not just by acting, but by not acting or acting very, very slowly on some very important issues, obviously raise, genuine questions in the minds of the people. The Babri Masjid case, to my mind, I mean, one cannot mince words. It was a judgment that nobody expected. Well, I did not expect that judgment because the Supreme Court went on to give a prayer that nobody asked for. So when the Supreme Court started hearing the Babri Masjid Ayodhya dispute, the Supreme Court Chief Justice then, Mr. Ranjan Gogoi, had made it very clear that we are going to look at this as a title suit. It's a land dispute, right? And the Allahabad High Court judgment, which was challenged in the Supreme Court, had basically divided the alleged disputed land one-third between the Hindus, the Muslims, and the Nirmohi Akhada. What the Supreme Court ends up doing is saying the entire disputed land goes to the Hindu side, so to say, and the Muslim side should be given a 5-acre land in a prominent place in the city. And several writers and commentators, of course, pointed out subtly in their own ways that yes, it was a title dispute, but it is not a question of just any parcel of land, saying that if you're given 5 acres of land, this is good enough. The question was that what existed on that historical place and just giving another 5 acres of land somewhere else, does that even go to the heart of the matter that the Supreme Court spent so much time hearing. So that judgment, of course, I think is a big blot, and I do think, without mincing words, that it's a judgment that will be seen by history in a terrible, terrible light. So, these
we have another speaker, Avni, so we would like you to really wind up now, because we have a video and we have another speaker. Thank you.
Absolutely. So I have made my broad comments. I think if the Supreme Court is to be, if moving forward, if it thinks that people's faith needs to be, in a way reaffirmed in the Supreme Court in particular, and in the Indian judiciary in general, it's very important that we go back to the basics, we go back to the roots. And at the moment, the roots unfortunately seem terribly shaken. Over to you, Ajit.
Thank you, Avni. Thank you so much for that absolutely amazing encapsulation of what's going down in India with the Indian judiciary. I work a lot here. My brother Matthias Patula of the International Christian Concern is here. He and I, we work on Capitol Hill. We connect with Department of State officials, government of the United States, and everywhere. Whereas people know about the fact that there are problems in India with the Hindu nationalists. Generally, it is assumed that the Indian judiciary it's beyond reproach. There is no problem with Indian judiciary, and eventually minorities get justice in India. And it is very true that is not the case. Like I said earlier, you've given a very detailed explanation. We have Brother Sukhman Dhami, but before I ask him to speak, I would like to go on and show you a video, which is a testimony of Akashi Bhatt, the daughter of Sanjeev Bhatt, who is India's most famous police officer. Sanjeev Bhatt has been convicted of murdering a man he never met. That is true. Mr. Bhatt, who is a member of the India's highest police service, it's called the Indian Police Service, the IPS. It's a federal agency. He has been convicted of murdering a man he never met, and the prosecution acknowledges the fact that the two never met. The prosecution even failed to establish that Mr. Bhatt ever gave any direct or indirect orders for the murder of the man. And here is the thing. Wait for the interview and hear it. The man was not even murdered. He was in police custody. He was released from police custody. He died more than 2 weeks later without any medical report pointing to foul play in his death. And yet, Mr. Bhatt has been sentenced to life imprisonment. I'm requesting my colleague Jawad Muhammad to please play the interview with Akashi Bhatt.
In 1990, Mr. L.K. Advani had carried out a procession, a Rath Yatra, to garner support for the demolition of the Babri Masjid, which later on happened in 1992. Shortly after his arrest by a chief minister of a state, Mr. Lalu Prasad Yadav, communal violence broke out across the country. The Vishwa Hindu Parishad and the Bharatiya Janata Party on the 30th of October 1990 declared a Bharat Bandh, a complete stoppage of all the functionings in the country. And on that day as well, there were little pockets across the country which experienced riots. In the state of Gujarat, there was a district named Jamjodhpur which also experienced rioting. 133 rioters were arrested in the morning between 9:30 and 12:15 by the local police inspector and his team. Any of these detained people arrested by my father were in custody of him or were ever interrogated by him. The very next day, the 133 rioters were presented before the Judicial Magistrate Court, post which they were put under judicial custody and then released on bail. One man out of the 133 arrested later on died 18 days after being released on bail. It is extremely strange that how a death that occurs 18 days after being released, so it is not even a custodial death, a death that occurs because of no indication of torture. All of his medical reports, his forensic reports, his post-mortem reports, histopathology reports, all of them clearly suggest that there is no evidence of any internal or external trauma. There is absolutely no evidence of any internal or external grievances or any injury. That this is not a death by torture. Yet this death is labeled as a custodial death, and the blame of which is put on my father, Mr. Sanjeev Bhatt, a man who never arrested him, whose custody he was never in, and who never even met the deceased. None of those people who the CID crime had interrogated 30 years ago were called in as witnesses. None of the officials who investigated this case were called in as witnesses. None of the doctors who carried out the post-mortem or who gave expert opinions on this case were called in as witnesses. No one directly linked to the case was called by the prosecution as witnesses. 33 people who had nothing to do with the case were called in as witnesses. It was placed before the court, but it was not taken under cognizance, and it was placed before the court by our lawyers, but it was not taken into cognizance. So these 33 witnesses comprised of people who perhaps officials who worked within the police station, who perhaps were responsible for moving papers from one office to the other or delivering posts from one place to the other. Some of them were also rioters who were arrested at that point in time, who are currently active members of the VHP and the BJP. These were the kind of people who were called in as witnesses. We were not allowed to call in a single defense witness. We want a fair trial. That is all that we have been pleading for, that take into cognizance all of these evidences, call in the people who are directly linked with the case, interrogate them, examine them, let us examine them, you cross-examine them. That is our only plea. Our plea is a fair trial. That is all. So like you clearly pointed out, on the 27th of February 2002, shortly after the burning of the Godhra train Sabarmati Express at Godhra station, an official meeting was called in by Mr. Narendra Modi in his residence, where he very clearly exclaimed that let Hindus vent their anger, and he directly gave orders to all the state functionaries to step down, look the other way, while the Hindus vented out their anger. My father was present at that meeting, which he later on in his depositions in 2009 and 2011 also said that to various commissions and the Supreme Court in his affidavit as well. Shortly after the 2002 riots, Narendra Modi went out on a victory march, going to different ghettos where the violence broke out in bigger magnitudes, and gave inflammatory speeches further stoking communal tension. The Minorities Commission ended up seeking for the tapes of Narendra Modi's speeches in order to further investigate. Now, at that point in time, it was due protocol for the Intelligence Bureau to record the speech of the Chief Minister, while all the other officials said that under extreme pressure, said that the tapes do not exist or we do not record on that day. Officers like my father, Mr. Abhishek Kumar, they came forward and they provided the Minorities Commission with the tapes. The very next day, all of the officials who did that were immediately transferred out on punishment postings. A very strong precedent was set right there and then that these are the officers who will not follow the regime's narrative blindly, that they will do their duty with due diligence. 2002, these people were transferred off on punishment postings to different places. My father was put off to Junagadh. In 2003, when my father was appointed as the superintendent of police of Sabrimala Central Jail, the man who was accused of having assassinated Mr. Harin Pandya, Asghar Ali, was also imprisoned in that very jail, and he had come forward and confessed to my father, saying that there was a third man named Tulsiram Prajapati who had actually carried out the assassination. As soon as new evidence came out, as per protocol, my father immediately called the then Home Minister then, Mr. Amit Shah,
who is now the Home Minister of India.
Correct, and told him about the new evidence that had erupted in the Harin Pandya murder case. And he was told that if there is any physical evidence about it, if you've written this down, destroy it, this conversation never happened. My father did not...
Are you saying that Mr. Amit Shah said this himself to your father? Yes,
I'm saying that he said this himself to my father.
Has your father put this conversation down on record?
Yes. So that is what I was coming to. That as soon as that happened, my father immediately put it down on record, on paper, the evidence as well as the phone call that happened, sent it off to the center, Home Ministry at the center in Delhi, the Prime Minister's office, the Chief Minister's office in Gujarat, and also Mr. Amit Shah, because he was the Home Minister of the state of Gujarat. As soon as he did that, the very next day, he was also transferred away from Sabrimala Central Jail and put away on punishment posting. In 2009, the court appointed a special investigative team to...
You mean the Supreme Court of
the
India?
Supreme Court of India appointed a special investigative team, an SIT, to look into, investigate the role of the state in the 2002 riots, to investigate the state's complicity in the 2002 riots. While all the other officials feigned amnesia or looked the other way or just succumbed under political pressure, my father was the only man who came forward and who truthfully deposed before the commission. In 2009, since 2009, my father has deposed before the SIT, the Nanavati Mehta Commission, which was also appointed, the Commission for Minorities, Supreme Court of India itself. All of these years, since 2009, no stone has been left unturned to deter him from deposing, to silence him, to break his resolve. But he relentlessly continued doing that at great personal and professional cost. In 2011, when my father submitted a sworn affidavit in the Supreme Court of India, putting forward evidence that could directly link Narendra Modi and Amit Shah to the 2002 riots, the various extrajudicial killings that the state of Gujarat witnessed following 2002 riots, the assassination of Mr. Haren Pandya, and also the collusion between the SIT, the very team that was appointed to investigate the state and the state that it was supposed to be investigating. My father put forward this affidavit in the Supreme Court in 2011, and shortly after his submission, he was suspended from duty. In 2014, as the BJP and as Narendra Modi grew in power, so did our vindictive victimization as well. In 2014, when Narendra Modi became the Prime Minister of India, shortly after him assuming office, my father was dismissed from duty under the frivolous ground of unauthorized absence. An absence that
he was sacked
courtesy,
from the Indian Police Service?
Yes. Absence which was courtesy him deposing before various commissions, his legal and moral obligation to go and depose before all of these commissions in order to shed light into the state's complicity in the 2002 riots. That was the reason why my father was dismissed from duty. As the BJP and Narendra Modi kept growing in power, their vindictive victimization kept on growing as well. My father is the sole surviving witness to the state's complicity in the 2002 riots. My father is the only man who can link Narendra Modi to the 2002 riots. Now, this is their attempt to finally tie the last loose end that can connect the present regime to perhaps one of the most horrific genocide in modern day India. In July 2018, all of a sudden, without any prior intimation or reason, was removed from the home. 1 week after the sudden removal of our security, our house was bulldozed while the family was still inside the house, and large portions of our house was broken down under the false pretext of it being illegally built. As if all of this, as if dismissing my father, suspending him, trying to malign his image and credibility, trying to victimize us for all of these years, breaking down our house, removing our security, as if all of these things were not enough. On 5th of September 2018, in the early hours of the morning, they came and they took my father away under the pretext of questioning him in a 30-year-old dormant case. And since then, we have been moving and running from pillar to post, trying to seek for justice, trying to seek for a fair trial, trying to seek justice for my father. This is a fight to the finish, which we will fight. We are fighting this legally, they are fighting this politically. We are trying to fight this within the legal norms of our Indian system. They are trying to put in each and every force that they have to silence my father once and for all. And I hope and I believe that their justice will be delivered, that in the end, truth will triumph over evil. Because my father has, for all of these years, relentlessly been the voice of all of the victims of the 2002 riots. He has defended, at great personal and professional cost, all of these people who could not stand up for themselves. It is now more than ever our duty to now defend the defenders when the very defenders are being victimized by this fascist system.
Thank you so much, Jawad Saab, for playing that interview. What powerful testimony, and it shakes us to the very core of our existence, our belief in how this is functioning. This case goes right up to the top, to the Prime Minister of India and to the Home Minister of India. Mr. Modi, his involvement in the violence against Muslims, in which more than 2,000 people were killed in 2002, and Sanjeev Bhatt is the sole surviving witness. And we have a situation where Sanjeev Bhatt has been sentenced to life imprisonment. You heard Akashi Bhatt. I want to quickly move on. We are already 1 hour into the conversation, into this webinar. I want to quickly move on to our next speaker. This is Sukhman Dhami, who I introduced earlier. He is the co-founder of and co-director of INSAF, which is a human rights organization that works towards ending impunity and achieving justice for the crimes against humanity in India, especially with regards to what happened in Punjab, where tens of thousands. I remember one case of extrajudicial killings. If I'm not mistaken, Sukhman will correct me. I think it involved about 10,000 people who were extrajudicially killed, and they were never accounted for. And there were people who took the case to the court, right all the way up to the Supreme Court, and eventually the Supreme Court acknowledged that these thousands of people were extrajudicially killed, and yet the Supreme Court of India refused to order an inquiry into that mass killing, which is just shocking. So over to you, Sukhman. You have another about 8 to 10 minutes. Please take it away.
Thank you, Ajit, and thank you to the Indian American Muslim Council for inviting me to this discussion. It's my privilege to be here with Avni and the other human rights defenders. Your work is, truly inspiring, and thank you for your courageous work. We all know that India has, unfortunately, a long and wide history of impunity for gross human rights violations. And, this impunity is maintained through its, 3 primary institutions. We know that there's legislation, whether it's the Armed Forces Special Powers Act or similar legislation that facilitates and emboldens security forces to commit impunity. We know that the executive branches, security forces, police enjoy impunity and protection for the acts that they commit. But what's often overlooked is the role of India's judiciary in upholding the culture and the policy and practices of impunity for gross human rights violations. This year marks the 25th anniversary of the enforced disappearance, abduction, torture, and ultimately custodial killing of the human rights defender Jaswant Singh Kalra from Punjab, who was ultimately eliminated for his work to investigate and expose enforced disappearances ending in secret mass cremations. Our work at INSAF over a decade and a half was inspired by his work and his example. And to date, we have publicly released over 5,300 incidences of enforced disappearances and extrajudicial executions, documenting atrocities committed by Punjab police and India's other security forces. Not only is this the anniversary of Jaswant Singh Kalra's 25th anniversary of his abduction and disappearance, it's also the anniversary of what is now over a 25-year-old case, which is known as the Punjab mass cremations case. And I want to unpack this case to illustrate judicial impunity for gross human rights violations. Jaswant Singh Kalra brought his findings of mass cremations and secret cremations forward in the mid-90s, originating in Punjab and Haryana's High Court, meaning his legal petition. And this is the origins of what you see is an ecosystem of judicial impunity that involves the Punjab and Haryana High Court, India's Supreme Court, and India's National Human Rights Commission. And to give you an example of how this case unfolded over the decades, when Jaswant Singh Kalra brought this issue of secret cremations to the attention of the Punjab and Haryana High Court, with credible allegations based on municipal cremation ground records that Punjab police had been secretly cremating thousands of bodies by declaring them unidentified. The Punjab and Haryana High Court dismissed this petition, saying that this isn't a matter of public interest and that only the individuals whose loved ones had been cremated as unidentified bodies had standing to bring their claims forward. And this response essentially made a mockery of these victims because it ignored the reality that if these are unidentified bodies, it is not possible to identify who the next of kin are. So Jaswant Singh Kalra was asking the court to identify who these unidentified secret cremation victims are, and the High Court's response was that only the next of kin of these unidentified individuals have standing to move forward, in this petition. Subsequently, Jaswant Singh Kalra was abducted and disappeared by a hit squad organized by former Punjab DGP KPS Gill and Ajit Singh Sandhu. And that subsequently led to two precedent-setting cases, fought by his family and continuing to be represented by his family today. You have the individual abduction and disappearance of Jaswant Singh Kalra, and his family then also petitioned the Supreme Court regarding his allegations of mass cremations, secret cremations, and forced disappearances and extrajudicial executions. To the Supreme Court's credit, the Supreme Court at that time did find a flagrant violation of human rights on a mass scale with respect to the practice of the police secretly cremating the bodies of individuals in these municipal cremation grounds in Punjab. What else was remarkable is that the Supreme Court delegated its authority to investigate this issue of mass cremations to India's National Human Rights Commission. Now, to provide the normal framework for the National Human Rights Commission, we have to look at its constituting act, the Protection of Human Rights Act. So under normal circumstances, this act was passed in 1993, establishing the National Human Rights Commission. And this act essentially puts the National Human Rights Commission in a straitjacket. The act says that the National Human Rights Commission cannot look at any violations prior to its constitution. So meaning no human rights violations prior to 1993. The act also says that essentially that the National Human Rights Commission cannot look at abuses committed by security forces. And the act also says that the National Human Rights Commission can only make recommendations, meaning it really only has suggestive powers. It can make observations, it can make recommendations, and then it's for the other powers that be to act accordingly. However, in this instance, because the Supreme Court was delegating its powers and anointing India's National Human Rights Commission as a sui generis body to investigate the issue of mass cremations, it had a much more expansive and powerful mandate. And even to this day, the National Human Rights Commission complains about its limitations. And it talks about how it's a toothless tiger. However, specifically in the mass cremations case, none of these restrictions apply. This is very clear from the Supreme Court's orders. This is very clear also from certain interpretations by the National Human Rights Commission itself. However, over a decade and a half of proceedings before the National Human Rights Commission, it went out of its way to abandon the mandate that it was given by India's National Supreme Court. And not only did it not utilize the expansive powers as it had, essentially the same powers that the Supreme Court would have to investigate issues of gross human rights violations, it even operated in a manner that's more restrictive than its own constituting act would allow. And an example of that is how it interpreted its mandate. Jaswant Singh Khalra and his family and other petitioners in this case presented clear evidence that mass cremations were not limited just to Amritsar district, that they in fact occurred throughout Punjab's, at that time, 17 districts. Petitioners further presented evidence that cremations were not the only manner in which security forces disposed of bodies, that they also dismembered and buried these bodies, and they also destroyed the evidence of their crimes by dumping bodies in rivers and canals and other waterways of Punjab. Despite this evidence, the India's National Human Rights Commission said that since the initial petition only brought forward municipal cremation ground records from Amritsar district concerning 2,000 bodies, that it was going to limit its inquiry to those 2,000 cremations. And further, it was not actually going to address the question of how these individuals became cremation victims. It was simply going to look at the very narrow issue of whether or not Punjab police followed police procedure with respect to notifying next of kin prior to cremating the individual's body. So the petitioners were arguing that the issue is not how is the body disposed of, but rather how did this individual become a body that ended up in the hands of Punjab police, while the commission was saying is that it had no interest in determining how that individual came to die, but rather was simply interested in determining whether or not Punjab police invited the next of kin to the cremation prior to the cremation occurring. And throughout the over a decade and a half of litigation, evidence was presented of enforced disappearances throughout Punjab, not just in Amritsar district. Evidence was presented of enforced disappearances, torture, and moreover, the devastating impact that these violations had on the families. But not only did India's National Human Rights Commission refuse to look at the larger issues, in nearly 2 decades of proceedings, to date, it has yet to call a single victim to testify about their experiences. And of course, at various stages, petitioners went back to the Supreme Court. They've gone back to the High Court. And as I mentioned earlier, this was an ecosystem of impunity. They've merely punted these issues back and forth, saying that this is no longer our responsibility. And they've, indicated that petitioners should either initiate new litigation or that, in fact, that the National Human Rights Commission's interpretation is correct. And it's important to understand the precedent that was set here, because this is a clear example of how the judiciary has worked. And this goes back to my colleagues, Avni's comments earlier, how they take something that is clearly a systems crime, something, a case, a matter that clearly establishes widespread and systematic patterns, and reduces it to a series of individualized incidences. And what this allows the judiciary to do is escape more fundamental issues like addressing command responsibility. And it allows the judiciary to escape addressing issues of whether these atrocity of crimes occurred according to a policy and plan, whether they were widespread and systematic, and it forces victim families to essentially litigate each of these cases as individuals. And this example in Punjab is not unique, unfortunately. India has been plagued by atrocity crimes, by crimes against humanity. In Punjab, you have mass cremations. In Kashmir, you have mass graves. In Nagaland, you've had, and Chhattisgarh, you've had whole villages that have been razed to the ground. And in each incidence, the response of the judiciary has been to overlook the widespread and systematic aspect of these abuses. And even where the petitioners have pursued this on an individualized basis through the remedy of habeas corpus, one of our earliest research examples of research, this incredible article that was written by Insaf's co-founder Jaskarn Kaur in Harvard's Law Review demonstrates that the total inefficacy of the habeas corpus remedy in the context of Punjab, for enforced disappearances and unlawful killings. And this has also been the experience of victim families in Kashmir and throughout India, for that matter. And it's amply demonstratable. As I mentioned, we've documented and publicly released over 5,000 incidences of enforced disappearances and unlawful killing. There's been an equal documentation of judicial impunity for these widespread and systematic crimes, both where individual families are pursuing disappearances and unlawful killings, but also in incidences where there are credible allegations of widespread and systematic abuses. And
so you have a minute to wrap up.
And so in conclusion, we often say how the failure to prevent and punish leads to the recurrence of crimes. Punjab is a clear example of that impunity. We know that officers in Punjab went on to replicate their abusive practices in other places, such as Kashmir, but we also see the judiciary replicating their abusive practices. Whether we're talking about the failure of the judiciary and the various commissions and the 84 pogroms context against Sikhs, whether we're talking about the 2002 genocidal pogroms, whether we're talking about mass graves in Kashmir, the judiciary has deliberately turned a blind eye to widespread and systematic abuses, and this has led to a black hole, a vacuum in the development of the law concerning not only individualized examinations of disappearances and unlawful killings, but also, the policies, practices, and the widespread and systematic manner in which these abuses unfold. And we also know that India is not, a party to certain optional protocols that would give international mechanisms oversight of these types of practices. And this strikes at the very foundation of India's democracy, where wholesale thousands of people, tens of thousands of people can be disappeared and killed, yet there's no acknowledgement of the systematic nature of these abuses by India's judiciary.
Thank you. Thank you so much, Sukhman. We have about 10 minutes into the webinar. I'm going to request my colleague and friend, Matthias Patula of International Christian Concern, to join us now and to talk to us briefly on the experience of the Christians, Indian Christians with the Indian judiciary. We see these cases all the time. One of the commonest occurrences with the Indian Christians is that when they're holding mass or they are praying at the church, there's a Hindu mob that descends on them, attacks them, and the Hindu mob is so bold and so fearless. It knows that it has impunity, that it actually records most of these attacks on video on their phones, and then it's the Hindu mobs that call the police, and the police come, and instead of arresting the perpetrators, they arrest the Christians, including pastors and priests and the congregants, and book them, charge them criminally for all kinds of outrageous allegations such as carrying out illegal conversions and all that nonsense that's happening in India. The day before yesterday, we had Brother Matthias Patula speak at one of our webinars, and he gave us details of how that goes down in India. So Matthias, you got about 5 minutes so that we can have some questions and answers at the end of it. So please go ahead and tell us more about this.
Perfect. Thank you so much, Ajit, and thanks for fitting me in at the last minute here to share a little bit more about what the Christians are going through. And I just commend all the remarks made earlier by the other panelists today. It's an honor to be joining you once again, and really learning a lot more about what the Indian judiciary is doing to propagate persecution and go after religious minorities. It's very concerning. And at ICC, we've been monitoring India for quite some time now, especially since the ascension to power of Prime Minister Modi and the BJP, and really the RSS, with their notorious track record of, victimization of religious minorities, has been deeply troubling. And as I shared on Monday, on the cases of persecution that we've seen in terms of Christian persecution in India just skyrocket since 2014. 147 cases as reported by our partners at the Evangelical Fellowship of India in 2014, all the way up to 360 some cases just in 2019, and that number is growing. And those are only verified cases of persecution that include violence, disruption of church services, desecration of graveyards and churches, and you name it, all the way up to rape and murder and other forms of violence perpetrated against the Christian communities there. I won't go into too much detail on all the different types of persecution that we're facing, since we're focusing on the judiciary. But one of the thoughts that came to mind that has been deeply concerning for us is the propagation of the anti-forced conversion laws, which are now active in 8 states across India, and also being propagated in other BJP-ruled states in India. And how these laws, in addition to the blasphemy law, are being used to persecute Christians and really give almost a sense of impunity for the Hindu radicals to continue their persecution of Christians in India. Ajit mentioned how one of the most common types of cases that we come across at ICC is exactly as you explained it. There will be a church service happening, a mass or some other Protestant type service happening, a prayer meeting. A mob of Hindu radicals will show up and they will disrupt the service. They will beat up the pastors and the other elders and leaders, and including all those in attendance many times. When the police finally do show up, they actually don't arrest the perpetrators, the Hindu radicals, but rather they arrest the pastors or the attendees at the church and take them to prison or to jail. And more often they are released, but they are also often not released, and they're mistreated while they're in custody. And usually it is on the basis of the blasphemy law or the anti-forced conversion law or the spirit of these laws that they are held. One of the ways that we've seen that in the blasphemy law, if a Christian is actually sharing the gospel or sharing their faith, under the blasphemy law, this can be interpreted as in terms of enraging the religious feelings of another, which runs completely contradictory to the Constitution of India, which guarantees the propagation and the discussion of faith under Article 25. We all know that. So the sharing of your faith and theological discussions and that debate should be welcomed in the Indian society, but in many parts, as we've seen, that is not welcomed. I'll share just a brief story with you that I shared on Monday, and then I'll wrap it up. I know we want to get to Q&A here. This is a very recent story. Happened in October. Actually, on October 16th, there was a Christian worship service was attacked by a mob of radical Hindu nationalists in India's Madhya Pradesh state. After being falsely accused of engaging in forced conversions, a pastor and 7 other Christians were taken into police custody for questioning. According to Pastor Parji, 30 to 35 radical Hindu nationalists barged into the worship service taking place in an India Gospel Church in Talabadi village, located in Adratma district. The mob was led by Bahara Gujar and Bhavarish Gujar, and forgive my mispronunciation of names, as I'm sure I'm butchering them as I'm reading. They confronted Pastor Parji and told him that the Christian worship should not be taking place in this village. And the pastor said the members of the mob pulled the Bible from the pastor's hand and yelled at him, saying that reading this Bible leads to many professing Christianity. They went on to tell the pastor that they would not allow this to happen in their village. Pastor Manijal started India Gospel Church in Talabadi nearly 35 years ago, and since then the church has been harassed even throughout its lifetime there. The harassment from the Hindu radicals is a constant thing, the pastor said. They bully us whenever we pass by their houses. They give us the ultimatum that we should close down the church because India is a Hindu-only country. Runs very contradictory to the secular nature of the constitution of India. According to Pastor Majilal, the mob attacked the church on October 16th, also pressured the local police into an FIR against the pastor, under the state's anti-conversion law. However, after initially taking Pastor Manjunal and the 7 other Christians into custody, the police released the Christians because no proof was provided by the radicals to support the FIR. Now, this is a case that actually ended well in terms of the situation for these Christians, but you can see how the law is playing into the hands of the Hindu radicals in this case, which is extremely concerning. And as I said, this is just one of many, many, many cases that we come across at International Christian Concern. Our partners report these cases, and it's just growing our concern for the Christian communities in India and really the entire religious minority communities in India, including Sikhs and Muslims and so on. So honored to join the conversation today. Thank you for having me, Ajit. I hope we make some meaningful progress through this dialogue, and it's an honor to be partnering with you as always, Ajit. Thank you so much.
Thank you, Matthias. We are now just 2 minutes out to the end of this webinar. If there are any questions, we have just 2 questions. Avani, would you like to answer why the lawyers in India do not speak out against Indian High Court for their biases? That's a question from Brother Akhtar Sadiq. Of course, you are a rare and courageous voice, and there are a few others. But why is it that most of the legal community, why do they choose to keep quiet?
I think there is a 2-layered response to that, Ajit. The one is that I think it's not true to say that lawyers are not speaking up. I am personally aware of very many lawyers, young and senior, not just at the High Court, but even the Supreme Court, who have been increasingly vocal, of what's happening overall in the country, specifically also with the judiciary. However, we cannot neglect the fact that there is this kind of crushing down of dissent of any sort, right? So for example, if we see the way young students have been arrested, the way journalists have been silenced, right? The way, these people seem to be struggling for their basic rights, right to a fair trial, right to be heard, means that there is a larger impunity in play. And there is a clear signal being sent, I must say, from the BJP that any voice of dissent will be crushed, right? So these are difficult times. I would go to the extent of saying that this is what we're seeing in India is some sort of an undeclared emergency, right? These are not normal times. But my own sense is that more and more people will speak up. It's right. One person speaks up, gives courage to 10 other people to speak up. What we heard, about Mr. Sanjeev Bhatt is extremely unfortunate, right? And there is a clear messaging out there that anybody who dares speak up will be silenced. Now, that means that, yes, not very many people are going to speak up, but I think the few, the courageous few, are still speaking up and will continue speaking up. And I think, I think the Constitution of India, and those who believe not in Hinduism or Islam or Christianity, but I think India's democracy continues to survive on the basis of those who believe in the Constitution of India. And I'm one of those, right? I'm not, I don't identify myself first as a Hindu or as a, or as a secular person. I identify myself as a constitutionalist. And I think as long as we have people who continue to believe in the spirit of India's constitution, India's democracy will be alive. It will be kicking and thriving. It may go through hard times, but it will very much be alive.
Thank you, Avani. Sukhman, any concluding remarks? Just very quickly, very briefly. We have already crossed the time of the webinar. So if you could just make your concluding remarks. You are on mute, Sukhman.
I would just encourage everyone who's been joining this conversation and listening and sharing it on social to find a way to support these courageous human rights defenders in India and to amplify their voices.
Thank you, Sukhman. Thank you, everybody, for joining our webinar today. This is one of the most important issues here. We see the experience of the United States. We are seeing that the strongest protests and fights in the United States are for justice, for legal justice. Coming from India, I find it most remarkable that in the US, the American people, all on both sides of the aisle, are very alarmed. They think that things are going really from bad to worse. But I come from India, and I marvel at the patience of the American people on both sides. They don't indulge in violence, very, very rarely. In fact, people protest. I live in Washington, D.C., but very rarely we see the kind of impunity, the kind of complicity, the kind of violence that happens in India. It's still so much better. If we can, even in India, start following the rule of the law as much as it is followed in the US, we will see a remarkable change. We need more constitutionalists in India. We need more human rights defenders such as Sukhman. We need more people to understand that the rights of all Indian citizens, it does not matter whether they are Christians or Hindus or Muslims, or Christians today and Muslim tomorrow, or Muslim today and Hindu tomorrow, or Hindu today and Christian tomorrow. It does not matter. What matters is upholding the rule of the law, and that can only happen if the Constitution is considered the final document. It is ironic that in June 2016, when Mr. Modi came to the United States as Prime Minister, he addressed the joint session of the United States Congress, and among other things, he said, the Constitution of India is our holy book. Now, that is something he needs to walk the talk. So thank you, everybody, for joining our program. This has also been live streamed on IAMC.com and MediaVigil.com. MediaVigil is a very brave and courageous a website of young journalists in India. They are doing absolutely amazing work. So you can watch our live stream this. You can watch this recording both on IMC Facebook page as well as on Media Vigil Facebook page. Thank you, everybody. Goodbye.